next question. The video was brought up, and I appreciate that we were able to watch that video, because there was an accusation made in that video, which I have heard throughout the state, and especially in this area, and that is that Georgia already has all the laws needed to approve charter schools, and that this amendment would create a duplicate agency to do what the state school board already does. Can we have a discussion with what led to this amendment to start with? Because I think the history behind the amendment is why we're actually having this amendment, helps to answer that question. And during that discussion, do we need this separate agency? And Representative Coomer, would you like to lead off?
Sure, sure. You know, one of the buzz phrases of conservative politics in Georgia and this country has been, we don't tolerate judicial activism. We don't allow it. You know, we're again it 100%. And really, this amendment issue arose because 4 of the 7 Supreme Court justices in our state Supreme Court became judicial activists, in this decision at least, and they frankly read words into the Constitution which are not there. And as a result, they struck down the charter system that's existed for the last decade in Georgia. And that really is what has precipitated the necessity for a charter amendment. And frankly, we talked a little bit about enabling legislation. With the enabling legislation that's been agreed on between Democrats and Republicans in the House and Senate and the governor's office, and the state superintendent's office, frankly, who was involved from day one in all of the legislative discussion, who had in fact approved the enabling legislation and the charter amendment until about 2 months ago. All of that language really restricts the system significantly from the far more open system we had until the Supreme Court decision. But to answer the question, it is a reaction to judicial activism that brings us to this amendment initiative.
Senator Rogers, following up on that, does this amendment, or the passing of this amendment, would it create a duplicate agency? I mean, you and I have all fought against duplication and waste and larger government, and some of our own compatriots on the conservative side have made the argument that this is government duplication. It's creating a new bureaucracy. Can you answer that question and explain if it does, why do we need it?
Well, first of all, if it wasn't necessary, I can assure you we wouldn't have passed it. Because, I mean, I know that sounds a little silly, but we would not have gone through this exercise, which was a long, arduous process, if we didn't need to go through it. No one, I mean, if it's already the existing law, we could have already done this. Obviously, we wouldn't have done it. Supreme Court ruled because there was something in place, the State Charter Commission, that I believe, as Representative Coomer said, for political reasons, they saw fit to get rid of it. But the real question is will this commission be another bureaucracy? This gets a little frustrating as well, because remember, the function of the commission is to perform as an appeals process to an applicant, a charter applicant, who's turned down at the local level. So all this commission would do is say yes or no to the applicant, the charter applicant, as to whether they believe that is a charter applicant that should receive a charter to begin running a school. Once that happens, it's not the charter commission that's hiring teachers. It's not the charter commission that's determining what books they're going to buy. It's not the charter commission that's going to find out the location. It's not the charter commission that's going to have anything at all to do with the day-to-day operation of the school. The day-to-day operation of the school is going to be run, as Dr. Reese said, by the parents and by the volunteers at that individual school. All the charter commission is, essentially, is an appeals process for an applicant that gets turned down at the local level. Now, why would they get turned down at the local level? To go back and use my restaurant analogy again, if you went and asked the McDonald's in Cartersville if they wanted Burger King to open up next door, and you said, look, it's your choice. You can either allow Burger King to open up next door, or you can turn down Burger King to open up next door. How many of them do you think would say, that's a great idea, let's open up a Burger King next door to my McDonald's? No one. So all this is an appeals process for all those Burger Kings that get turned down. And if you look at the way the commission worked before it was ruled unconstitutional, it worked exceptionally well. They didn't just give the green light to everybody. In fact, there were, 86 applicants, I believe, and only 16 or 17 got approved. So they were very picky and choosy. And remember, these people are working for free. We're not paying them anything. These are volunteers who have expertise in the area of education that look at these applicants because they want a well-educated Georgia, which is what everybody on this panel wants, which I assume everybody in the audience wants. These are people working for free, simply providing a public service. I'm like you, Senator Lubbock. I'm against bureaucracy, Representative Coomer. This is not a bureaucracy when you have volunteers willing to serve their state.
Professor?
I'm right now in a very, I guess maybe unique position. I'm on the board of the Georgia Charter Education Foundation, and we have 2 charter schools that were commissioned under the, authorized under the commission that existed for, 3 years. One of our charters is just coming up for recommissioning again. Now, there is no commission. So this whole notion of who's in control, and you've got to have local control, and there's an unelected board that's going to be in control. Well, right now, there is no unelected board, and we are going through our reauthorization. I'm in the very middle of this. And I must say that we are dealing with the Board of Education. Again, there's no commission, so they can't be in control. We're dealing with the Board of Education, and I tell you that they are not trying to take control from us. They are trying to push control to us. They are insisting that we take charge of the governance, and even we've only been in operation for 2 years, so things are still very young and needing to mature and everything. And I'm right with them that the parents and the community board are learning to take control themselves. So it's not a shift from is the state taking control or is somebody else taking. It's the state wants the parents in this case to take control and to take responsibility. Because remember, on the other side of this control is accountability, and that's something that the charters have that the other schools really don't so much. So I will tell you from somebody on the ground and on the battle lines on this one, that we are not struggling with the state and trying to take control from them. They are pushing it towards us and strongly encouraging and insisting that we develop ever more refined governance structures.
Rich?
Yeah, I just want to add that I know we're in Bartow County, and it's not exactly Metro Atlanta, but it's close enough to be considered the metropolitan area. I grew up in southwest Georgia, and in my home county, a little bit southeast of my home county, there was a school that was started called Watauga Charter Academy. And one of the things that they experienced, which I think really gives a real good example of why we need a state commission, is that in order for that school to get started, not only did they get told no one time, but they got told no 5 times by 5 different counties that they now pull from. So going back to Senator Rogers' example, they had to ask 5 different McDonald's, could we open up a Burger King? And they all said no. But fortunately, during the period that they were getting started, there was a state charter school commission that they could go and appeal to. As a result, that school was opened, and this past year, it outperformed in nearly every category of reading, math, science, social studies than the 5 districts that told them no just a few short years ago. If we did not have a commission, there would still be several hundred kids in rural South Georgia stuck in a traditional system that was quite comfortable just doing things the way they've done for the last 100 years. That's why I find this constitutional amendment so vitally important, not just to some parts of Georgia, but all across the state.
Tony, we've vetted this pretty well, but I don't think we've answered one of the key accusations that we hear from video and throughout the community and through different organizations that oppose this amendment. Why do we need the commission? Because, as it was stated, we can already do this. The department or the Board of Education can already do this. Why do we need a commission?
Well, there's a lot of truth that we can already do it. We've been doing it for 10 years, as the representative said. But then the Supreme Court made the decision that stated the one word that was inserted that was created out of nowhere. They said that local school districts have exclusive control over K-12 education. Now, that one word exclusive was not there. It's funny, later in the Constitution, it did say that the Board of Regents has exclusive control over colleges and universities in Georgia. So it wasn't that the Founding Fathers didn't know the word exclusive. They just didn't choose to use it about K-12 education. So because of that, it is called into question whether the state of Georgia has a constitutional ability to approve charter schools. And what will cease it would be a lawsuit placed by some school districts who would say to the court, the Supreme Court said that local school districts have exclusive authority in K-12 education, but over here's the state approving charter schools. What do you say? And I'm not an attorney, but I know a lot of attorneys, and they all say the same thing. The court would rule on the basis of the Supreme Court decision and tell the state, you can't approve charter schools. Now, I brought that up in several forums, and the opposition always says, they're school districts. We would never sue. What gives them that idea that we would sue? Well, it's a funny thing. 5 of the school districts got together and sued back in 2008, all the way to 2009, took it all the way to the Georgia Supreme Court. They not only wanted the Georgia Commission, Charter School Commission, declared unconstitutional, they wanted every school that had already been approved, even those that were open, charter schools, I'm talking about kids in these schools, they wanted them all closed. Now, I find it very easy to believe that they would sue. And here's their strategy. Strategy 1 is to get this amendment defeated. Case closed, problem solved. Strategy 2, if we don't pass the amendment, they're going to then go back to court. They got plenty of lawyers. Talk about for-profit people. I love attorneys. We need you. But I've never had one that gave me free services either. They spent a lot of money. And we had, as an association, by the way, our little charter schools operate on very little money. We paid for their defense. It cost $350,000. $350,000. In my opinion, wasted money, because it should have been spent on the kids, defending our charter schools to keep them open. So I'm not going to believe that they're not going to sue. The day, if the amendment does not pass, the day after or soon after that, they'll file suit asking the court to tell the state you can no longer approve state charter schools.
Thank you. I think that's a very good discussion. We're going to move on.